Alrighty, well, we're back to Corporate Law 101, an entrepreneur's guide, and we're in the home stretch now, folks. We're at Section 3, Part 1, and we're talking about the Board of Directors. A Board of Directors is a group of individuals that are elected by shareholders, and they act as representatives of those shareholders and direct the company management, including policies and helping to make the major decisions for the corporation. Okay. Generally, there's an odd number of directors, 1, 3, 5. You don't want so many that you can't deal with, and that you have to have monstrous meetings all the time. What you're really looking for is a group of individuals that can help you direct the company. You want to make sure that you have an odd number because it avoids the lockup of the directors. The majority wins, and so you can move on. We're going to go into more detail on what the bylaws say and how you kind of govern that. And we use the board of the bylaws a lot to facilitate the goals and objectives for particular director responsibilities by changing the bylaws. So we change the bylaws, add or subtract things that we do or don't like our directors to do, and that kind of sets the tone for your company. And remember, the more directors there are, the harder it is to manage. But remember also that the board makes decisions on shareholders for the shareholders' benefit. Okay, and they make it as a fiduciary. They have a responsibility, a legal responsibility, and we'll talk more about that in a second, to protect the interests of the shareholders. And they can get sued personally if you don't. Okay, so now the board of directors' key purpose is to ensure the company's prosperity by collecting and directing the company's affairs, while at the same time, making appropriate interests of its shareholders and stockholders money, so that it can make profit in some form, or at least show the growth and things of that sort. Now, okay, how does this really happen, Mike? I have this company I just started, and I really want to start a board of directors. Well, first of all, you go around and find people that might be interested in sitting on your board of directors. Let's assume a normal company would have 3. Yourself would be 1, and you want people that will vote along with you, but that are not yes men or gals, because you just don't want somebody that's going to tell you what you want to hear. You want to have somebody that will push back, but in a manner that isn't, grating on the way in which your personality operates. Okay, so you want to stay away from close friends who, could have a relationship with you and just think that they want to go with you. At the same time, you don't want people who are going to fight with you every 2 days over something silly, okay? Then what you do is you call a meeting. You call the original founders shareholder meeting. All the subscribing shareholders show up. They have a meeting, and then they vote for 3 directors, or as many directors as they want to have. And each vote gets 3 votes. So if there's 3 directors, you get 3 votes. That's generally called cumulative voting. And again, you'll find that in the bylaws. So the election of the directors then goes on a majority vote for each of the directors. And then the people who with the top 3 votes end up being directors of the company. Now, the board really has ultimate decision-making authority and is generally empowered to do a lot of things. They can set the company's policies, objectives, and overall direction for sure. That's what they're supposed to do. They adopt revised bylaws, as we just talked about. They name members of advisory and executive and financial committees so that they can, you can look at different things like Joe's a CPA. He might be good in the financial side of the business. Let's let him be a board of director for the financial side of this and help us manage the company from a financial perspective. Another lawyer, a businessman, a banker, a financial analyst, a venture capitalist. If you're in a technology company and you're not a technologist, of course you want a technology person. If you are a technologist, you probably want someone who has good business skills, understands the models of technology, but doesn't necessarily get down and dirty on Java code and HTML5 and URLs and DNS and what is it, Amazon Web Services, AWS, all those acronyms. Okay. The other thing a board does is that it can hire, fire, and evaluate managing directors and senior executives. And that's important. So you're really now electing the officers And remember, the board of directors are personally liable for the decisions made by the board. The other thing the board can do is determine the pay and when dividends are paid. And they have one other big attribute: they can issue shares and dilute the other shareholders. Okay. Now, all members of the board are not generally involved in the day-to-day operations. The board legally is held liable under the doctrine of collective responsibility for the consequences of the firm's policies, actions, and failures to act. So that it's not just, did you do something, did you fail to do something? So you really need some advice and counsel from a business lawyer who understands what it is that your risks in your particular marketplace are, and you want to have discussions of that. Now you don't have to have them every Thursday, but you can have them once a month. That gives you 12 meetings. You'll begin to understand a marketplace at that point in time. Most companies are regulated by the state at the state level. So there's no standardization of methods for forming a board. You literally just go and elect the board. You don't have to apply to the state or notice the state. On your state renewals and sometimes on your state applications for articles of incorporation, you'll be asked or required to name your board of directors. So you want to think about that as you're setting up the company. If you've already got a company and you already have bylaws, but they're dusting, they've been in the bottom drawer for 25 years, get them out, clean them up, look at them, make sure you hold a special meeting of the shareholders, elect a board of directors, ratify actions that you've already taken, things of that sort. Get an attorney that knows what they're doing, that can sit down and talk you through some of these actions. Okay. Again, the directors are elected at the first annual meeting, and they can run for generally 1-year terms. However, you also, by statute in almost every state, you can have staggered board of directors. So your one director could be for 1 year. Let's just say that's your outside director. Your hand-chosen financial guy is for 2 years, and you as the owner are the third board of director, and you have a 3-year term. So now it takes, everybody, there's only one seat available every 3 years, that kind of thing. So it's a little more complicated to deal with, but it keeps the ability to have somebody take over the company by a coup from the board of directors. It slows that down considerably. Now, removal of directors. So, I've got a bunch of directors. How do I remove them? Okay. Each state's a little bit different here. During the course of his or her term, you can go and terminate a director for cause. And those are pretty specific things: fraud, misrepresentation, things of that sort, sexual misconduct, fiduciary duty breach, things of that sort. Again, your bylaws will tell you more about that. Okay. Since the function of a director is a fiduciary duty, the directors are really in control of the other people's property, the shareholders' property, and their powers are derived primarily from a statute. And so that you basically have criminal statutes that say if you don't do this, you have problems. And this is where we talk about breaching the corporate veil, and we'll talk more about that in the next section. This is what the kind of actions that they would look to as to whether or not you're really acting as a corporation or whether you're acting as an individual and should be charged individually, which can add, personal liability, both you and in some cases, and I'm not trying to scare you because it doesn't happen often, but criminal liability. But certainly civil liability happens pretty regularly, and that's what I'm saying. My case studies tell me that this is happening a lot more in a lot more jurisdictions, and so we've got to be much more diligent on the types of information and the types of meetings we have, and then how do you remove a director, basically for cause or not for cause. If you're not for cause, the director can sue you. There's case law in that regard. So you be careful when you do it without cause. If you do it for cause, you better be careful about making sure that the cause is reviewed with appropriate counsel and that you have thought through the process of how you're going to do that for cause. Unless, of course, there's an emergency situation, then just do it, get it done, and then find your attorneys right away. Okay? By the way, the liabilities, and again, I'm not trying to scare you, but the liabilities of directors extend to both their individual and joint actions. So just because, Marty and Mary and John are on the board, and Mary decides she wants to go off and do something crazy, doesn't mean that the other two aren't potentially liable for that. Okay, how did they know? Was it a part of her duties? Was it restricted under the bylaws? What rights did she have within that? How are they? Couched, if you will. Did you, tell her she could go out and do certain kinds of things and she exceeded her duty by a small amount, or no, she went in an area she never should have been in, and we have a problem. Okay. The decisions regarding supervision of the entire enterprise, including your products and services. So, if you have a poisoned product for some reason and it's negligence on the part of the directors, you were told or you didn't bother to find out. Again, these are the things the court looks at to breach the corporate veil and see if they can't get to you personally. Directors are bound by certain duties, such as the duty to act within the scope of their authority and to exercise due care in the performance of their corporate tasks. Now, that's along the lines of what we were just talking about, is as management of the board, you really need to kind of limit those functionalities so that the individual directors, of which you now are liable for, don't go off in left field on you, and if they do, that you have specific remedies, including throwing them off the board as you go. Okay, let's kind of change topics for just a second. We're going to go to the bylaws, and the bylaws basically lay out the directors. They also lay out the terms of those directors. They lay out when you should have meetings, how you elect a chairperson, what powers and duties the directors really have of the corporation, and then how are they paid, compensation. Okay. Now, I guess long term, what you're trying to do is recruit directors who can govern the company that you aspire to grow from a small business into something mighty. From little acorns, mighty trees grow. And it's so true because, the companies I've started, we sold one, one of my lady clients came to me, had a business idea. We took it, we got it together, got her funded, got her programmed. She had a programming application. She was a certified financial planner and a CPA, and wrote a spectacular program. We sold her company to one of her largest competitors for $5.3 million 18 months later. It happens. So if you think this isn't important stuff at the start, you're crazy, because you never know where you're going. And if you're just here to kind of, mosey along, then, I guess you don't have to do this and just leave yourself at risk. But if you're, serious about business and growing, you better start putting these things in order. Now, you also want to find in a director a go-to guy or person, lady, that you have at least one director who understands board governance. Let's call it a corporate secretary type of person, okay? You don't want to rely solely on the lawyers and accountants, because they are only looking at their own vertical. They're not looking at the horizontal, which is the business aspects and the implications of some of those decisions. And most lawyers won't make the decision for you. They'll tell you what the decisions are, and then you make a decision. The accountant's going to tell you what the impact financially of this decision is or that decision. Again, they're not there to tell you what the decision is. A board of directors is there to help you make the decision. Create good job descriptions, guys. Establish clear understanding of what you expect out of the directors, both the executive directors and those that are not on a day-to-day basis at the company involved. That's generally the difference between the types of executives you have. And define the role that the board will play in the strategies, in the risk management of the company, in the development of technology. Let me give you an example. If you're the chairman of Oracle Systems, Oracle Inc., I believe it is a technologist and has intellectual property rights and owns huge amounts of shares and obviously influences the board. And how does the board, work around that? And how does the board avoid, playing favorites? Luckily, the chairman of that company's a very smart man, understands how those work, has been working for a long time and growing a spectacularly valuable company. So, it's tough though. I'm sure he had a lot of, sleepless nights on how do you do that and who do you trust and things of that sort. You want different kinds of folks, as I said, on the team from a director's perspective. You don't want yes men or yes ladies. You want people who will apply their own intelligence to the issue and bring you different viewpoints. At the same time, I really agree with a lot of the authors that said, again, lean towards likenesses, because you don't want to be fighting with your directors over silly stuff. If that starts to happen, have a shareholder meeting and decide how you're going to go forward with the board. That needs to be thought through. Okay, understanding how these directors are paid. Pay them fairly and equivalent to their role within the company, and ask others how they're compensating their board of directors within your industry. And then, lastly, it's important that they really understand from the beginning a boardroom hierarchy. Remember that the executives and officers of the company report to the board from the beginning, even though one of the members may even be on the board, but have the board members be ready to challenge and questioning of the logic and wisdom that those people are bringing and asking you to undertake as part of your decision-making process. Okay? Now, as we go to these board meeting and shareholder meetings, we need to be keeping records, commonly referred to as minutes of meetings for the board of directors and shareholder meetings. First thing we want to know is there a quorum? What's a quorum? A quorum is there enough people to have a 51-49 vote, or 51% or more of the shareholders at the meeting? So that's a quorum. Now, the bylaws, again, we talked about the bylaws, can change a quorum requirement, especially for certain types of meetings. But generally, a quorum is 51% of the voting members available to vote at that time. What is the date of the meeting? What time did the meeting start? What time did the meeting end? What were the discussions held? And what were the resolutions adopted by the board or shareholders at that meeting? And most of all, who were the attendees? Well, why is this important? Well, there's a big Disney case that basically the Disney folks, the owners, Mr. Disney, one of the Walt Disney's brother, decided that he and a group of his fellow shareholders did not like the decision by management related to the payment to an executive who had left the company. They then filed suit against the board of directors and said that the decision had not properly been discussed and that the resolutions were very tautily written, in fact. And they went clear to the Supreme Court in the state of Delaware, and Mr. Disney lost. The Disney Corporation won. However, in that opinion, the judge really talked about the discussions that these folks had, and had they been more upfront about what they discussed, they would have avoided a lot of the problems and the challenges by the individuals that Mr. Disney's brother represented. On one hand, you don't want a lot of detail. On the other hand, you want enough to show that there was reasonable discussion of the matter and that the board took it seriously and spent the time that is reasonable to the value that is being given on a particular issue. Now, a board resolution basically authorizes a specific act of the corporation, such as accepting a loan from a shareholder, authorizing the issuance of additional shares, as we talked about earlier, electing officers, but also approving the strategic decisions, especially such as the sale of the company or a significant asset, such as maybe software or hardware technology or intellectual property patents, things of that sort. And as I said, the discussions really need to be noted, but not in a lot of great detail, because you really don't want to tell too much about what's happening at the company. At the same time, you really want to talk about this Disney case that we were just talking about as it relates to the amount of information covered. And that's it for now for this tutorial. Well, thank you very much for taking the time to go through this tutorial. These tutorials are copyright 2017 BrainTech CSI Inc., all rights reserved.